Okay, could you again just announce the time?
Good afternoon. It's now 1:32 p.m. And the commission will be coming out, back out from executive session.
And so can you attest for the record that only the matters discussed in the motion to go into closed session were the only matters discussed in the closed session? Can you so attest?
I can so attest.
Okay.
Thank you. So we're back on the record, back on open session. I see counsel here for our second case, but we need to wrap up our first case for a few minutes here. The commission deliberated on OCC case number 25371 in closed session this morning. We went through hopefully a reasonably thorough decision, and the vote on the order was unanimous.
Well, first, let's do that. So Commissioner Thompson, there's an order in front of you. Do you make a motion to approve it?
So moved.
Is there a second?
I second.
There. Okay, please proceed now.
So unanimous approval of the commission decision in OCC case 25371. In this case, the commission has ruled in favor of Permian and all pending other. So that means we have granted Permian's application in case numbers 23508 through 23523. Denied Coterra's application in case numbers 23448 through 23455 and case numbers 23594 through 23601. All other pending motions are denied. This order will go into effect 20 days from the date that this order is filed and served, and all previously issued stays in this case will be lifted on that same date. We will hopefully the order will be fairly self-explanatory. We did spend a good amount of time on it, and I have signed it. It will be served electronically by the end of the day, but Sheila has a couple of hard copies. So for counsel who are with us on that particular case, you're welcome to pick up a hard copy from Sheila, from our counsel clerk, commission clerk, excuse me. Well, with that out of the way, I think we can turn to the next case on our agenda, which is Goodnight versus Empire, per the pre-hearing order. So give us just a minute to reorganize ourselves and we'll proceed in just a few minutes. All right, everybody appears to be ready to proceed, so I will call the hearing on the pending motions and consolidated cases between Goodnight Midstream and Empire New Mexico I won't read the whole list of cases because there's quite a few of them, but I presume we are all here for the right case. So if I could have the appearances of counsel to begin with, that'd be appreciated.
Good afternoon, Mr. Chair, Commissioners. Dana Hardy and Corey Waymauer on behalf of Empire New Mexico LLC.
Thank you.
Good afternoon, Commissioner Chang. Adam Rankin with the Santa Fe Office of Holland Hart, appearing on behalf of Goodnight Permian LLC with my colleague, Paula Vance. And with us today in the audience is some representatives from Goodnight Midstream. We have Grant Adams, who's the Chief Executive Officer, and 3 Goodnight Midstream board members, Mr. Drew Winston with Tailwater Capital, Mr. Charles Marsh, and Mr. Patrick Walker, also joining us today. Thank you.
Thank you.
Good afternoon, Mr. Chair. This is Miguel Suaza with Beatty and Wozniak appearing today on behalf of Pilot Water.
Thank you.
Chris Moander on behalf of OCD.
Matt Beck on behalf of Rice Operating Company and Permian Line Service LLC.
Thank you very much. Well, I believe at this point unless there's any objections, I believe we're ready to proceed according to the order as laid out in the pre-hearing order. So please proceed.
Thank you, Mr. Chair. I think we have feedback, but thank you. And I will present the first part of our discussion, and then Mr. Waymauer will present the second part. And we do have a PowerPoint presentation that we are planning to share. Okay, and I will be brief here because I know we don't have a lot of time, but just by way of brief background, we had a many-week evidentiary hearing in this matter, and the commission announced its decision in August, suspending Goodnight's injection permits and denying its permits for new wells. The order was entered in September, and then there were exchanges between Goodnight and the division and suggestions that the commission's order provided guidance, and it seemed unclear to Goodnight and that the permits had been actually suspended. So Goodnight continues to disobey the order and has done nothing to curtail its injection at this point. The suspension order clearly stated that the commission suspends Goodnight's existing injection wells. It's not ambiguous, and that was done to afford Empire the opportunity to commence its CO2 enhanced oil recovery project. But again, Goodnight continues to inject despite the order. The commission's findings were numerous, as I'm sure you all remember, and one of them involved the unit agreement, and it's shown here in section 10 specifically gives Empire the exclusive right, privilege, and duty of exercising rights within the unit with respect to unitized substances. Additional findings of the order that are critical are listed here. The findings were made again to allow Empire the opportunity to commence its CO2 project, which it is not able to do while Goodnight is injecting. And this is important. One finding by the commission was that water is moving from the St. Andres into the Grayburg, and that was found based on Dr. Buckwalter's model that was noted in the suspension order, and that itself establishes waste and violation of correlative rights because the Grayburg, of course, is included within the unitized interval for the Eunice Monument South unit. And that finding was substantiated by core saturations, which also showed vertical fractures in the St. Andres and Grayburg, explaining why high water volumes were produced from the Grayburg prior to the water flood. So we presented conclusive evidence that water was migrating from the St. Andres into the Grayburg. So in summary, based on the extensive evidence presented at the hearing, the commission correctly denied Goodnight's applications to drill new wells, suspended their existing wells, and denied the injection increase into the Dawson well. And despite those findings in that order, Goodnight has continued to inject, and Goodnight has also attempted to subvert the commission's decision through proceedings before the division. For example, Goodnight recently submitted a filing before the division where it essentially argued that it prevailed in this proceeding, which is not what the order said that the commission issued. Goodnight is contesting Empire's standing before the division to object to the Rocket SWD extension, even though the commission has already ruled that Empire had standing to apply to revoke that permit, and that application is pending before the commission. So Goodnight has continued to use processes to sort of try to subvert the commission's decision and avoid stopping its injection. The commission properly issued the suspension order. Goodnight would have the commission sit by until the hydrocarbons are destroyed and Empire has no option for recovering them. But that argument directly contradicts the commission's obligation to prevent waste and protect correlative rights under the Oil and Gas Act. The standard for rehearing is high. It requires a change in controlling law, new evidence that was previously unavailable despite due diligence, or the need to correct clear error to prevent manifest injustice. None of these circumstances exist here. Goodnight merely wants to take a second bite at the apple and rehash its failed claims that it previously made to the commission. And importantly, a party may not use a motion for rehearing to re-argue issues already decided or to submit evidence that could have been presented earlier. Otherwise, parties would be able to relitigate proceedings and there would be no finality if you could wait till the hearing was over and then decide you should have presented something else, which is exactly what Goodnight is doing here. So the statutes on waste, I think we're all familiar with them. The division and commission have absolute plenary authority to take action to prevent waste and protect correlative rights. And part of that obligation involves the prevention of encroachment of water that tends to reduce the total ultimate recovery of crude petroleum oil for any pool. So it's broad authority, and the commission is obligated to prevent waste and protect correlative rights. And the statute, which we've discussed extensively in our briefing, refers to waste as any activity that tends to reduce, which is important language, because Goodnight is construing it as really actually reduce. And the actual reduction has to be proven, and that is not what is required by the statute. So we've summarized the statutes in our briefing, and Goodnight is misinterpreting them. And in addition, the commission looked at the Statutory Unitization Act, which applies here, of course, and gives Empire the exclusive right to operate within its statutory unitized interval. Goodnight and Rice in their briefing incorrectly rely on the division's provision on injection, which states, it's part 10 of Rule 26, the division may restrict the injected volume and pressure for or shut in injection wells or projects that have exhibited failure to confine fluids to the authorized zone. And they have argued that that means that the commission and division can only act if there is a failure of an injection well to confine fluid to the approved zone. And that's not correct under the law. The duty to prevent waste and protect correlative rights is an overarching obligation. And really what Goodnight and Rice are trying to do here is read only into that provision. The division may only restrict, and that is not what it says. And according to their interpretation, that would mean that if a producing interval was erroneously included in an injection interval, the commission and division could do nothing unless the fluid had escaped the zone. So it's clearly not correct. Goodnight's claim regarding a continuous barrier is raised in their briefing, and that's the reason that they posit several hundred pages of new exhibits. And they raised the continuous barrier theory throughout their testimony and exhibits, and we've discussed that in our brief. They posited that as a reason that they should be allowed to inject. So for them to come back and claim now that the commission erroneously applied a continuous barrier theory is not correct. And in any event, an applicant for injection must always establish a confining zone with upper and lower barriers. That is always the case, and that is well established in the regulations and even in the permits themselves. Goodnight, again, wants a second bite at the apple. They've attached pages and pages of new evidence. There's nothing new about the continuous barrier theory. It's a confinement determination that they are required to make. Their exhibits could have been presented at the hearing. For example, they've included seismic data now after the commission asked Goodnight's witness at hearing if they had seismic data, and they said yes, but they could not provide it due to licensing restrictions. Well, they've come back now after they did not get the result they wanted and are presenting seismic data in their exhibits to their motion for rehearing. So it's not appropriate to relitigate these issues after the fact based on hindsight, and none of their new evidence should be considered. They raise constitutional arguments. I'm not going to go into detail. I think they lack merit. The injection permits on their face state that the commission and division retain jurisdiction over them to prevent waste and protect correlative rights. They're revocable permits depending on those parameters. They raise arguments regarding surface ownership and alleged constitutional rights of surface owners when Goodnight itself sought to exclude any evidence of surface ownership at the hearing. They objected to that evidence and their objection was sustained. So they can't come back now and argue surface ownership should be considered. They've waived that argument. There's no basis to grant Goodnight the do-over that it seeks. The commission carefully considered voluminous evidence, and Goodnight's litigation choices do not amount to a basis for rehearing. Rice and OCD submitted responses to the rehearing motions that, specifically with respect to Rice, really constituted joinder in Goodnight's motion, which isn't a proper response because Empire didn't get a chance to respond to it. Because instead of filing their own motion for rehearing, they submitted arguments in response. And with respect to OCD, OCD had withdrawn from the case, as you know, before the hearing, and is not adversely affected by the order. OCD does raise issues regarding enforcement proceedings and how they typically handle them, but this is not an enforcement proceeding. The commission has already heard and the parties have litigated the validity or invalidity of Goodnight's permits. So the issues regarding the handling of enforcement proceedings are not relevant. They don't apply to this situation. It's a different situation here where we've had a mini-week hearing. Empire has submitted a limited request for rehearing, demonstrating that the permits should be suspended permanently. We have presented evidence of violation of correlative rights and waste. And Goodnight fails to meet its burden for stay. The Tenego factors are discussed in our briefing. None of them are met here. They are not met. There's no likelihood that Goodnight will prevail on appeal. There's no irreparable harm to Goodnight. Substantial harm will result to others if a stay is granted. So a stay is inappropriate. Again, we've talked about these issues in our briefing, and clearly based on the evidence that's been presented extensively and that the commission carefully balanced, the order is correct and the suspension must be enforced. And then I will turn it over to Mr. Waymauer.
Thank you very much. We spent 5 weeks presenting witnesses in this case. You may recall that despite Goodnight's appearance today, not one single Goodnight witness actually bothered to come here in person. And we also didn't see anybody attend 4.5, 5 weeks of testimony and official proceedings from Goodnight during the course of the case. History is watching what we're doing right now. During those 4.5 weeks, we spent a lot of time reading transcripts from testimony before the division and commission from over 40 years ago. Empire is here asking that the commission's final suspension order be enforced, exactly as it's written, be enforced. If that suspension order is enforced, this can be a wonderful success case for the state of New Mexico. You have Empire, who is here ready, willing, and able to execute this ROS development in the San Andres, and for that matter, also in the Grayburg. And it also intends, for the benefit of the state of New Mexico's minerals and the United States' minerals, to continue its water flood operations in the Grayburg. If the permits are not suspended precisely as the final order of the commission says they are suspended, and if they continue injecting, this is destined to be a failure. There's no two ways about it. There's no halfway about it. It will be a failure. They went into this. I want the commission to remember that they went into this knowing that the MSU unitization order was in effect. They testified that they knew about it and they proceeded anyway. They continued to inject in violation of the suspension order. Empire is merely asking that the suspension order be enforced, that the permits be suspended exactly as the commission ordered they are. In all of the paper that you've seen over the last 2 weeks, neither OCD nor Goodnight has pointed this commission to one single instance in the history of time in which a permit was suspended, that is suspended, but injection continued. And we've looked for such a situation. We haven't found one. Additionally, we heard after witness, after witness, after witness, there are 77 million acres in New Mexico. We're concerned about the injection within 14,000 acres out of those 77 million acres. Tell us where in the history of time in New Mexico, a saltwater disposal trash company operator has injected into a unit that per its express terms gave exclusivity to Empire. Never in the history of time could any Goodnight representative or expert point to a single place on the face of the planet Earth that has ever allowed injection into a unitized interval except for what they are doing here. They told you, despite them coming in here and doing the injection, that they didn't perceive this as being their charge to provide any kind of a science case or an engineering case for what they were actually doing. Their expert witnesses told you all that they perceived their charge as merely throwing rocks and picking at and trying to destroy the science and engineering case that Empire went to the laborious effort to properly develop and bring here. There's discussion about they want curtailment. They want the injection volumes to not stop exactly as occurs with a suspended permit. They want the volumes to somehow be curtailed on a going forward basis. After 5 weeks of testimony and deliberations and argument, the commission did not order that suspension should be curtailed over some period of time. The commission ordered that it should be suspended. This is consistent with the pattern of Goodnight from the very jump of this case, which is delay, because they know that every single day that they thumb their nose at the rights granted in the 1984 unitization order, and every single day that goes by that they thumb their nose at this commission's final order ordering suspension of those permits, is money that they get to put into their pocket and send back to Dallas, Texas and Fort Worth, Texas. Delay equals money, and it has been the objective of Goodnight from the start to delay this inevitable outcome as long as they possibly can. Enough is enough. It needs to stop now. The commission's order should have been observed months ago in August when it was announced. It should have been observed in September when it came out in writing and was signed unanimously and executed by the commission. It certainly should stop as we come here today. Why is that so important? You've heard testimony straight from Empire's witnesses about how once the harm is done, it can't be undone. This comes from concepts such as raising the pressure. No doubt the pressure here is being raised in the San Andres through the continued injection. Comes from water incompatibility. This is makeup water that's used in the Grayburg. This is higher operating costs. This is the actual formation being cemented up by the incompatible water. You also heard straight from their expert, Mr. Macbeth. He was asked, will any company, investor, as part of an EOR in the San Andres touch the MSU while Goodnight continues to inject tens of thousands of barrels of wastewater every single day? And you heard straight from Mr. Macbeth that there is nobody on the planet is going to touch the San Andreas Ross MSU development, be it pilot project or commercial development, unless and until the injection is stopped. Why are we asking that the commission step in here and enforce the order? Well, consistent with the goodnight tactic of delay to the ends of padding its wallet, Goodnight's already reached out to the commission with a vastly different interpretation of what a suspended permit means as to these 4 wells. This is in the evidence that has been appended in the recent filings. Goodnight would like to schedule a meeting with the division regarding the commission's guidance for implementing the order, when, how, and over what period of time Goodnight will be required to shut in its disposal wells. This commission did not order curtailment. It did not order that the permits would be suspended at some day in the future. The commission ordered suspension of the permits, full stop, period, now. Nowhere will you find, other than conclusory allegations, any kind of a safety concern that comes out of stopping the injection. If you wanted to believe Goodnight, these wells operate on a vast vacuum. They just suck the water down with no equipment necessary to even pump it down. It's on a vacuum. Nowhere in these papers will you find any kind of a safety issue if they just stop putting the waste into the exclusive depths that Empire, per the 1984 order, has the right to operate and develop within. The OCD's response was that it cannot and will not make any guarantees or assurances as to how it will ultimately decide to implement the order, including timing and nature of actions OCD may require of either Goodnight or Empire. We cannot get going on our pilot program that the commission has allowed 3 years to implement and execute unless and until the injection starts. We agree with Mr. Macbeth on that. Their expert, Mr. Mc, we completely agree. It has to stop before we can commence the pilot program that the commission has allowed. OCD has said it cannot and will not make guarantees on any of that time. We didn't want to come here on the motion to enforce. It's shocking to me that this motion to enforce was necessary. On behalf of Empire and on behalf of the state of New Mexico's minerals and the United States' minerals, we beg the commission that we leave here today with certainty that the waste injection, that the harm that's occurring stops today, so that Empire can proceed precisely consistent with the property rights that it purchased and that have been established since 1984. This being no drastic departure. Again, this is the only place on the planet Earth in which anybody has identified a disposal company injecting into a unitized interval in violation of Empire's rights. I'm at my time. If there's any questions, we're very happy to field those. The presentation goes in, there's probably 3 inches of filings y'all have gotten. The presentation was our effort to bring it down to 82 slides of points that might be a little easier to digest and less paper. I very much appreciate the commission's opportunity. I thank the commission on behalf of Empire for all of its time, the last 4.5 weeks, and certainly the time today to present these arguments.
Thank you. Feels like we have closer to 3 feet of filings, but fair enough. Commissioners, any questions?
Is it possible to listen to all the parties and then probably? Okay, thank you.
Would you like to also reserve your questions?
Yeah, I'm fine with that as well.
I do have a couple of questions. I didn't hear much argument about your own motion for a rehearing. You are also seeking for a motion for rehearing.
It's very narrow. So in contrast to the arguments we've seen over here that accuse the commission after all this work of arbitrary conduct, capricious conduct, and it having no jurisdiction, apparently we spent 4.5 weeks and y'all didn't have any jurisdiction. This was news when we got the filing. All we are asking for is that in light of the correct legal standards, which we've cited, that just some minor cleaning up in terms of the verbiage in the order. They've said they're going to challenge us every which way on appeal that they can. We think there's some places that the verbiage could be altered. Additionally, to just address the appellate points that they say that this commission without jurisdiction have already committed. And then again, we would maintain our frontline position that with this valuable ROS, everyone agrees it's a ROS, even their witnesses, that with this valuable ROS, the permit should just be straight revoked. And in the alternative to revoking, we would ask that the language be cleaned up and against the suspension. We will be back in 3 years or earlier to show this commission what an outstanding decision it made after 4.5 weeks of testimony.
Let me ask a specific question about the Derrick versus Standard Standard Nutrition Co. case that you cited in on page 10 of your packet here. I presume that same standard for rehearing applies to all parties before me. So what new evidence that could not have been presented earlier is Empire proffering to support its motion for rehearing?
We have no new evidence. So if the standard here is new evidence that wasn't available at the time of hearing, we certainly agree. We're not bringing any new evidence. We had 4.5 weeks. The commission was so patient with us. We are not suggesting that any new evidence is appropriate.
That's all the questions I have at this time. Commission counsel, do you have any questions at this time? No, sir. All right. In that case, I invite Goodnight for their presentation.
Commissioners, Chair Chang, Commissioner Ampoma, Commissioner Lampkin, good afternoon. May it please the commission. Goodnight respectfully filed its application for hearing to correct several critical errors that were included in the order. To avoid error and entry of an order that's arbitrary, capricious, and not in accordance with the law, we respectfully ask the commission to grant Goodnight's application and issue an amended order that incorporates the legal and factual corrections that we've outlined in our application. Specifically, we ask that an amended order be issued that approves Goodnight's applications, withdraws the suspension of Goodnight's existing injection operations, and removes the San Andres from the EMSU unitized interval. First, based on the findings in the order, the commission lacked authority to order the relief Empire requested and properly refused to revoke Goodnight's injection permits. But the very same findings that were insufficient to revoke Goodnight's injection permits also were insufficient to grant the partial relief Empire did not even request, temporary suspension of Goodnight's injection. Second, in granting partial relief, the commission failed to apply its own regulations that control under what circumstances the commission or division even has discretion to curtail, shut in, or suspend injection operations. Instead, it applied a new, more stringent continuous barrier standard that is being invoked for the first time against Goodnight and only Goodnight, and has not been applied against any other injection operations in the state, including those EOR operations within the EMSU itself. Third, compounding that error, the commission improperly shifted and applied the burden of proof to Goodnight when the burden should have been on Empire as applicant seeking to shut in Goodnight's injection. And finally, the commission's key findings on two issues that both Goodnight and Empire agreed are dispositive in these cases, including all the cases that are currently pending before the commission and stayed, actually support denial of Empire's claims and requested relief. Those dispositive findings are that the purported ROZ is not recoverable and that there's no finding that it is even capable of producing in paying quantities. And I just point out that we strenuously disagree that there is an ROZ down in Goodnight's disposal zone, and that Goodnight's injection is not impairing Empire's operations in the EMSU. Empire agreed in its briefing on the scope of this hearing that those two issues would be dispositive of all the cases against Goodnight, and the commission has now found in Goodnight's favor on those two key issues. There are at least four broad overarching reasons that Goodnight's requested rehearing and modification order is warranted. I'll walk through each point that are outlined in detail in our papers and that support our requested relief here, in whole or in part. First, the commission's order goes beyond its authority because it didn't find there was impairment and it didn't find hydrocarbons capable of being produced in paying quantities. Second, Empire failed to carry its evidentiary burden and the commission applied the incorrect legal standard. Third, the commission's findings actually support Goodnight's position and continued injection. And fourth, if the commission maintains its continuous barrier standard, Goodnight should be given the opportunity to present evidence addressing this new standard that was announced only after the hearing. Finally, if the commission nevertheless disagrees with Goodnight and declines to grant the requested relief or the alternative relief proposed, Goodnight asks for this alternative relief. First, to amend the order to clarify that suspension of injection is delayed until Empire actually commences CO2 flood operations that actually targets Goodnight's disposal zone and not some shallower target. Or provide that Goodnight's suspension is to be implemented over time as Empire meets its demonstrable milestones necessary to implement a CO2 that they're so certain to do. I'll talk through each point and go through the requested relief. First, the commission acted beyond its authority. It did so in at least a couple of ways. First, most glaringly, the commission erroneously reaffirmed the error that it made back in 1984 when it confirmed that there are no recoverable hydrocarbons in the San Andres, but nevertheless allows the San Andres to remain within the MSU's unitized interval, thereby authorizing the unitization of an aquifer, which belongs exclusively to the public in contravention of the state's constitution. And the order also violates the Statutory Unitization Act because it confirms in the order that there are no recoverable hydrocarbons in the San Andres, which has never produced any hydrocarbons through primary production, and finds that the San Andres was included in the MSU solely because it was a water supply source. There's simply no legal or factual basis for the San Andres to be included within the unitized interval. Having found that there are no recoverable hydrocarbons in Goodnight's disposal zone and that Goodnight's injection is not impairing Empire's operations in the MSU, findings that there is no waste and no impairment of correlative rights, the commission lacks authority and discretion under its own regulations and statute to shut in Goodnight's injection. There's just no valid legal justification for it. So the order only found that there's a potential for future impairment or waste, but that finding is premised on an invalid evidentiary standard, and we believe also incorrect, unsubstantiated facts. Second, Empire failed to carry its evidentiary burden that there is waste and impairment, but the commission also applied the wrong standard and improperly shifted the burden to Goodnight. As part of its burden to prove waste and impairment, Empire had to show that the purported ROZ is capable of producing in paying quantities. Without that foundational showing, there can be no waste and no impairment of correlative rights because there's no recoverable oil and gas to waste and no share of production to protect. But Empire did not make that showing. It couldn't prove that the hydrocarbons in the ROZ are even recoverable, let alone that they can be produced in paying quantities. Empire has therefore been unable to show impairment of correlative rights in either the Grayburg or the San Andres. As to the Grayburg, Empire was unable to show any volumes in the Grayburg that are not being recovered due to Goodnight's injection, or that there has even been a reduction in production from the Grayburg at all. In the San Andres, Empire was unable to show that the alleged ROZ can be practicably produced from the Grayburg or the San Andres, or that it could even be recovered at all. In fact, Empire did not present a single witness who analyzed ROZ recoverability based on actual data from the EMSU. So there's not even an evidentiary basis in the record from which to draw the necessary conclusion. For a reservoir to be within the jurisdiction and authority of the commission to protect, it needs two things. One, to find that there are hydrocarbons capable of producing and that they are capable of being produced in paying quantities. Having found that Empire could not prove and did not prove that the ROZ was even recoverable, especially not in Goodnight's disposal zone, the commission did not even need to reach the decision about whether the ROZ is capable of producing in paying quantities. But in any event, Empire did not make out even a basic economic case because it failed to use any of the MSU data or analyses relied on by any of its experts in its made-up economic model that was instead based entirely on assumptions unsupported by actual MSU data. The commission therefore properly found that Empire did not prove recoverability by a preponderance of the evidence, and therefore did not need to reach the question of whether the ROZ could even produce in paying quantities. Empire's ROZ claim died before proof on the paying quantities element was even necessary to assess. Because without proof of recoverable ROZ, there is no waste and there's no impairment of correlative rights. Now, Empire also failed to carry its burden to show Empire's, Goodnight's wells have exhibited failure to confine injected fluids within the disposal zone. That's under the regulations. That standard comes directly out of the Commission's own regulations that govern and define under what circumstances the Commission has direct discretion to curtail, shut in, or suspend injection. Without proof of actual failure to confine injection fluids, the Commission is without authority to curtail, shut in, or suspend Goodnight's injection. The instance where Ms. Hardy referenced, where if there was some error in the inclusion of an improper zone, that's not the case here. There's no question that the injection fluids are going into the authorized injection zone. The question is whether or not those injection fluids are being confined. As the applicant to shut in Goodnight's injection, the burden to prove failure to confine was solely Empire's, and they failed to make that showing. Now, nowhere in the order does the Commission make the necessary finding that there was lack of confinement. Instead, the Commission improperly flipped the burden and mistakenly determined that Goodnight failed to refute potential future waste and impairment because it did not prove the existence of a single continuous barrier. But that's a new made-up standard that conflicts with governing regulations, with the agency's federal UIC primacy authority, and it improperly shifted the burden from Empire to Goodnight. That standard, to my knowledge, has never been applied before, nor has it been applied to existing water flood injection operations within the EMSU or anywhere else in the state. That is the definition of arbitrary, capricious, and not in accordance with the law. Moreover, the continuous barrier standard creates a new precedent that will have far-reaching negative consequences on the division's UIC program, including existing and future disposal operations, as well as enhanced oil recovery injection, risking the stability and reliability of the state's injection program and its ability to manage produced water disposal and EOR projects going forward. That raises substantial concerns of great public interest. Now, while the Commission did not find Goodnight's wells exhibited a failure to contain injection fluids, a critical finding that they didn't make, it actually found the opposite, that there is no communication between Goodnight's disposal zone and the Grayburg. Now, the citation that Counsel for Empire referenced, paragraph 47 of the Commission's order, is referencing the potential for future communication. In fact, the very line that they excluded to mention in their citation is that this could lead to communication between the Grayburg and San Andres. The finding regarding Dr. Buckwalter's analysis is that it could potentially lead to communication between the San Andres and the Grayburg and the San Andres, as the Commission order subsequently identifies that there has been no communication to date and no impairment. So based on what it actually found, what the Commission should have determined, based on the findings it made in a correct application of the law, is that because Empire did not prove failure to confine injection fluids, the evidentiary burden never shifted to Goodnight. There was nothing for Goodnight to refute. Now, the third reason Goodnight's application for rehearing should be granted is that the Commission's findings that are substantiated by the evidence support Goodnight, not Empire. Real quick, the Commission found that ROZ recoverability and paying quantities have not been proven. Without those findings, there is no waste and no impairment of correlative rights. The Commission found that correlative rights are not currently being impaired based on Goodnight's compelling engineering, injection, and pressure data. And the Commission also made no finding that Empire proved Goodnight's wells have exhibited a failure to confine the injected fluids. That Empire was unable to prove lack of confinement after more than 6 decades of continuous injection into the San Andres in and around the EMSU is substantial evidence that injection is and will be and continue to be confined to the disposal zone. Now, if the Commission rejects Goodnight's arguments and maintains its new continuous barrier standard, Goodnight should be afforded the opportunity to present evidence at a limited, narrow rehearing addressing this new standard. Up to and through the hearing, Goodnight believed and understood reasonably that the applicable standard required to show only that the injection was being confined to the injection interval, which was done. It relied on its engineering and injection data for that reason, which the commission found to be the most compelling evidence of no communication. Now, if Goodnight had known that it was required to actually prove the existence of a continuous barrier, that it would have presented at the hearing additional evidence and analysis of its 3D seismic data. Now, its application for a hearing, we did include an initial analysis of its 3D seismic data that ties the geophysical analysis to well logs and confirms the existence of a laterally extensive confining strata 60 to 200 feet thick, demonstrating that Goodnight's injection is and will remain confined. Now, if the commission maintains this continuous barrier standard, Goodnight should be given the chance to present a full analysis on this data and a subsurface model to avoid prejudice. Now, in the event the commission refuses to grant in whole or in part Goodnight's requested relief, to rescind the order temporarily suspending its injection and grant Goodnight's pending application, Goodnight requests that the order be amended to provide the requested alternative relief. Why? First, because the evidence supports it. And second, because Goodnight has invested millions of dollars on its 4 wells at issue in this case that support actively, currently, more than 30,000 barrels of existing oil production per day. And it has invested more than $300 million in its Llano pipeline system and associated injection infrastructure. In contrast, Empire has taken no steps, invested no capital necessary to begin recovery of its purported ROZ, let alone demonstrate that it's recoverable. Given the status in the commission's finding, why should Goodnight be forced to immediately shut in its wells? It shouldn't. Given that the ROZ contains, by definition, only oil that cannot be mobilized by water, continued disposal of produced water until Empire might be approved for a CO2 EOR project will not affect the ROZ. There is no evidence it will be impacted. And even if the commission refuses Goodnight's even if the commission refuses Goodnight's rehearing request, it should nevertheless amend the order to clarify that Goodnight's injection can continue until Empire actually begins a CO2 flood that actually targets Goodnight's disposal interval and not some shallower zone. Doing so would require Empire to obtain all the necessary regulatory permits for EOR injection, implement the necessary capital expenditures and facility modifications, procure the necessary CO2 for injection and rights of way, and demonstrate that it's prepared to immediately commence CO2 flood operations. This alternative relief aligns with the commission's finding in the order that disposal cannot coincide with the proposed CO2 flood operations in the same interval. That's the key. It has to be the same interval. If the commission determines that Goodnight's injection should nevertheless be curtailed or suspended in advance of CO2 flood, then injection should be curtailed in an orderly schedule tied to Empire's demonstration of concrete milestones towards its EOR project. If any of those milestones are missed, we believe that Goodnight's injection should be allowed to then resume and the injection suspension lifted and Empire's pilot project terminated. So requiring Empire to meet these milestones is justified and necessary where its viability as a going concern is uncertain and has been for years. Finally, should the commission refuse Goodnight's application for rehearing and reject its proposed alternative relief, the commission should enter a partial stay of the order, staying suspension of Goodnight's injection until final resolution of an appeal. Failure to do so will have substantial adverse effects on Goodnight, offsetting production operations and third-party disposal operators, as well as the state and public interest more generally. We've outlined those arguments in support in our papers, including the self-affirmed statement of Goodnight's chief executive, Mr. Grant Adams, and we believe the motion more than meets the requirements to issue a stay. But I'll make just 2 points in response to Empire's opposition. First, Empire seems to believe that Goodnight's arguing it has a vested property interest in its injection permits. That's not the case. Goodnight has a vested property interest in the San Andres pore space through its leasehold estate. And the commission's order, without a finding of recoverable hydrocarbons and current impairment, completely wipes out Goodnight's property interest in that pore space without a proper purpose. That is a regulatory taking. Second, Empire complains that Goodnight seeks an asymmetrical stay, staying only the provisions applicable to Goodnight and not the 3-year time frame to implement the EOR project. Well, Empire elected not to challenge that 3-year timeline to conduct their EOR, so there's no basis to stay that aspect of the order. In conclusion, you have been more than attentive throughout these proceedings, briefing and arguments presented by the parties, and we appreciate your careful consideration. The decision in this case, and getting it right based on the facts and the law, is important to Goodnight. It's also critical to the state of New Mexico, offsetting operators and third-party disposal operators. But it's also of utmost importance to ensure a stable and reliable permitting program under the Class 2 UIC, including enhanced oil recovery. Before I conclude, where am I? Okay. A couple of points just to make in response to some of the comments that Empire made in their statements. The evidence of the fractures, this is in our papers, that were presented to the commission, the alleged to be the pathway for communication, do not reach the confining zone that Goodnight has identified. They're more than 90 feet short. There's no direct evidence and no indirect evidence of any fractures that would allow for communication between the two zones. The reason Goodnight objected to the introduction of its leases and arguments around leases at the hearing was because Empire was seeking to introduce that evidence to show alleged trespass outside of its authorized boundaries. So we objected for a different reason, not because we objected on the introduction of the surface lease agreements. They were presented to the commission previously already. They're of record. We just objected for their testimony alleging that there was a trespass. To Mr. Waymar's comment that we were unable to identify any other in the history of the world saltwater disposal well anywhere on the face of the earth throughout history that failed to inject authorized injection within another unit. That's not true. The testimony actually identified at least one other in the North Monument unit here in New Mexico. There are more than one instance where the division or commission has authorized a saltwater disposal well in a unit. And often it's a similar situation as this one where it's injecting into the San Andres because the San Andres is non-productive and it was erroneously included in the unit and it shouldn't have been. Okay. It's not a hydrocarbon producing zone. And that's the reason it's different. It's not that the saltwater came to the disposal came to the unit. The unit came to the pre-existing saltwater disposal. As to the unit itself, again, the unit erroneously included the San Andres, and it shouldn't have. We appreciate your attention. On behalf of Goodnight Midstream and the board, I'm grateful for your attention and careful consideration in this very important matter. Thank you.
Any questions from commissioners at this point?
I'll reserve my questions.
Not at this point.
Commission counsel? No. Thank you. I don't have any questions for you at this point either. We will proceed then to OCD.
Good afternoon, commissioners. Chairman Chang. Just a point of clarification on order. I have not heard any party reserve any remaining time left and just want to clarify that will not be available in the future. Is that correct, Chair Chang?
That is correct.
Okay, thank you. I'm going to do this in slightly reverse order than I had intended. I'll discuss OCD's motion as the secondary aspect of things. But first off, I'm going to address the targeted criticisms towards OCD made by Empire initially to clear that up. The first argument that was made by Empire towards OCD and their role in enforcing the subject order at issue here is that OCD was not adversely affected, and that's just pure basura. That is not true. OCD had obligations imposed upon it, additional duties, et cetera, from the commission. So it has in fact actually been adversely affected, and it's certainly, I'll get to the issue of duties and obligations that OCD now has placed upon it by the commission. The second argument made was that this is not an enforcement proceeding. That's abundantly clear, and at no point did OCD claim it ever was. That's a red herring argument. The reason why that was brought up was only because OCD's primary experience, which was provided through an affidavit and resume of Deputy Director Brandon Powell, outlined that enforcement proceedings are the context in which OCD is most familiar with suspension of permits and the process that tends to follow from them. And that is why it's made the proposals that it did that I'll address here in a minute. Therefore, OCD would contend that its experiences are highly relevant and should inform the commission about how it handles these suspensions. At this point, this appears that Empire is being coy and disingenuous about matters. I mean, there was a whole bunch of flattery made to the state and the commission and oral argument. OCD's suspicion here, because Empire didn't actually touch OCD's proposal for their plan, not at all. And why would that be? Well, during the course of testimony in the hearing, it did in fact come out that Empire has financial problems. And if an EOR project is permitted to proceed, which this commission has in fact ordered, there are no guardrails on how that project should proceed. No discussion of filing deadlines, no discussions of proofs provided to OCD that progress is in fact actually being made. Because at the end of the day, this is a veiled effort to park this particular project and hold on for 3 years without actually having to demonstrate anything until that 3-year deadline expires. So this is why OCD is involved and seeks the clarity that I'll address momentarily. OCD has a duty to ensure it complies with this order, and it requires clarity as to, for example, shutting down injection wells, which entails issues like safety and also prevention of additional waste. And there are environmental considerations that also come into play. And it would appear that that's just not a concern of Empire whatsoever here. So having put to rest the criticisms that were made of OCD, I'm going to go ahead and turn to our proposal. OCD had some difficulty in deciding whether a rehearing was actually in and of itself the correct vector to take to address its concerns, but ultimately chose to respond to both the application and motions for rehearing. What OCD has proposed here, and this can be found on Exhibit A, page 5, paragraph 10, is conventionally when OCD suspends a permit, it does allow benchmark, like sub-deadlines under a major deadline of 90 days for winding up operations. This is largely done to ensure that the wind down is done properly, safely, and thoroughly. This can be done a number of ways, which is why I think perhaps some additional testimony might be useful for the commission as to how that proceeds in more excruciating detail. But ultimately, in no event should it take longer than 90 days to do a shutdown. And that, from OCD's perspective, that's reasonable, safe, and appropriate because it does prevent potential waste almost above anything else. There also is a lingering question here in OCD's mind, whether or not this suspension is effective immediately, and if so, would seek that 90 days in order to allow Goodnight to properly wind down everything and shut in the wells to OCD's satisfaction. Alternatively, if the suspension were to be contingent, although the order doesn't seem to reflect that, I do think it's worth mentioning, it contingent on Empire initiating, otherwise advancing its EOR project, that would be a very different scenario, and OCD would want some additional guidance on that point. Now, turning to Empire, the order does not, it only provides a 3-year deadline and nothing more as to how Empire is to proceed with its EOR project. Deputy Director Powell's recommendations are found on page 7, the enumerated paragraphs of OCD's response. These are a bit more specific, primarily because OCD has handled other pilot projects in the past. That's something that Deputy Director Powell's pretty experienced in. And this sets out some deadlines as to performance by Empire to complete that project. But just as importantly, there's a question of if deadlines are missed, whether or not OCD may be able to construe a failure on Empire at any given point in time as a failure of the project, at which point that would need to be addressed again with the OCC because the suspensions are contingent on the EOR project. If the EOR project fails, that brings into question the status of the suspension of Goodnight's permits, which will need further further clarification. And the additional factor in this is that recoverability, as OCD reads the order, is not guaranteed. It has not been proven. That brings into question the potential success of this project. And while that may be the intention of the project, that's still a concern for OCD. Thus, OCD believes that the EOR project that Empire now has the right to proceed with needs additional guardrails, deadlines, clarifications. And so with that, I will pass the microphone back to the commission.
Thank you. Commissioners, any questions at this point for OCD counsel?
I'll reserve and then come back. Thank you.
At this point? Counsel? Great, thank you. I don't have any questions either. We'll proceed to statements from Rice, please.
Commission Chairman Chang, thank you. Thank you all for your attention. Thank you for bringing us back again. It's wonderful to see you all again. Hopefully this won't be the last time. You know, there's been a lot of criticisms of the commission's order, and no one has ever accused me of writing 10 words when 5 words would suffice. Let me say that again. No one has ever accused me of writing 5 words when 10 words would suffice. And so sometimes that happens. I think that the commission's order is clear in context, and I may be not joined by a lot of folks in that opinion. But it seems to me, particularly when you read the headings, that the commission reached the finding that it is possible that there is a ROS down in the San Andres that may be produced at some point in the future. It seems the commission said, we want to see if that's possible. It seems the commission said, seems like the evidence said to us that if there's ongoing injection by Goodnight in the targeted zone where they want to produce the ROS, that conflicts with their ability to test that space. Now, this seems to me more like a gotcha, or as my colleague said, coy and disingenuous. I think we can see that from the ad hominem attacks from Empire. I think we can see that from its classification of the commission's order as, quote, the suspension order, which it is not. It is an order that provides Empire the ability to go and test its pilot project as Empire requested. And it does so after finding that there is not current waste or impairment of correlative rights. It does so in finding that the injection of Goodnight is not impairing recovery or causing waste in the Grayberg currently, but it might for a pilot project if and when Empire comes to the commission or the division, applies for that, and is granted that authority. Empire attacked Goodnight here and in all the papers for seeking guidance from the division, for going to the division and saying, we attended the September 12th hearing. We requested of the commission the timeline for suspension of our permits. The commission told us the division is charged with implementing this order, go to the division. Goodnight heeded that advice, sent an email to the division requesting that meeting. Carbon copied all counsel, inviting everyone to go and do that. The division took them up on that, and that's when the emergency motion to enforce the order happened and the motion to stay happened. Now, that was the proper thing for Goodnight to do. That is being a prudent operator. It is heeding the commission's directive that the division would implement this order. And I think that we can all see from the division's response why that is the proper route for this to take. Now, the commission was not aided by briefing on what suspension means and what happens when there's a suspension. That's because it came up as an idea in the hearing, was not aided in briefing with the parties. It was not outlined what the standards are or what the effects are of suspension. And again, that makes sense in the context of the commission's order, that if and when Empire seeks applications to commence a pilot project for CO2 EOR recovery, then the division will look at that order and Goodnight's injection authority will be suspended at that time. Now, the gotcha nature of this order, this proceeding by Empire, I think, is most exemplified by what is now new evidence, which is that they cannot go forward now if Goodnight's injection authority, Goodnight's injection continues. They just can't do it. And it's interesting that that is nowhere in the commission's findings. The commission was very specific in its findings of where it came up with this idea. And that appears in paragraph 64 and 65 of the commission's orders. When Dr. Mpoma asked whether Empire would be okay with allowing it, with suspending Goodnight's injection permits while it did an EOR project. And in that exchange, it says, would Empire be open to that? You know, you're getting me in more and more trouble with Mr. West, but I think we could do it within a couple of years. So within a couple of years, Empire will have the opportunity to drill the other wells? Yes, sir. And prove to see that if any of those claims, you know, real evidence that the ROZ indeed exists, it's recoverable. Yes, sir. Commission goes on talking to Mr. Wheeler, mainly speaking about if you guys had consent from the commission to establish an EOR project and you committed capital from your company, what do you think the timeline is in reference to Commissioner Mpoma's question about performing a pilot to verify that the ROZ is there and it's producible? You just do a small pilot project and the commission requests it. I believe that we can get it and do it within that 2-year period where we're talking about drilling the wells and coring and then the analysis and everything of that to present it to the commission. Nowhere in that exchange was it qualified that only if Goodnight's injection stopped immediately, they could proceed with that. Why? Because that was never part of it. Now, Mr. Waymeyer said that this, and I wrote it down, suspension order says that it suspends existing Goodnight's injection wells, the Dawson, the Banks, Sosa, Rhino, full stop. Now, if you look at paragraph 3 on page 13 of the order, that's not at all what it says. And it's important that's not at all what it says because, as I said, I think the commission's order was clear. It says, suspends existing Goodnight's injection wells, Dawson, Banks, Sosa, Rhino. And it goes on. In order to provide Empire with the opportunity to establish the CO2 EOR pilot project. And so the commission had in mind, as is clear from the order, that this would happen if and when Empire sought a CO2 EOR pilot project and was granted that authority. And that makes sense because if we go back to the beginning of this entire exercise, it is about an ROZ, a residual oil zone. And what you did not hear from Empire, but you did from Goodnight, is what we all know is the definition of a residual oil zone, which is that the oil has been washed out by Mother Nature's water flood, and it is immobile to water. And so the continued injection of Goodnight, even if there is an ROZ down there, does not cause waste, does not impair correlative rights. That oil is immobile to water. It is now, it has been since it was there, and it was washed out by Mother Nature's water flood. And it will be if and when anyone ever seeks to do a recovery project in the lower San Andres where Goodnight is injected. So I think it is incumbent on the commission to, now that you've been presented with this, make that clear. I think that the OCD standards set forth are reasonable. But I do think that from the commission's order, that suspension is and should be contingent upon Empire applying for and being authorized to conduct the pilot project. Thank you.
Thank you. Any questions from commission at this time, or would you like to reserve?
Yeah, I'll reserve if pilot has anything. Yeah, thank you.
Same for council? Great, thank you. I don't have any questions either at this time. Thank you very much. And I believe we have Pilot Water Solutions.
Good afternoon, Commissioners and Mr. Chair. This is Miguel Suazo again, appearing today on behalf of Pilot Water Solutions, SWD. I can assure you I'll be brief. Pilot appears today in support of the motions for rehearing submitted by Goodnight and Permian and in opposition to the one submitted by Empire. We think that a limited rehearing to correct the internal inconsistencies and to make clarifications in the order would be proper, especially since, you know, all the parties here are going to be living under this order for the foreseeable future. Now, Pilot's taken a pretty small role in this proceeding, despite its length and complexity. And that's because, you know, the well that it has in the EMSU is, you know, pretty marginal compared to some of the other wells in and around it. But Pilot's followed these proceedings very keenly, you know, awaiting the outcome in the commission's decision. And, you know, Pilot is concerned that this decision is going to impact not just it, but others in the industry that perform in the same lines of business. So in my distillation and understanding of what the order entails, we don't believe that Empire did adduce substantial evidence that its correlative rights in the Grayburg are impaired. And we think the record pretty clearly demonstrated that there's no fluid migration, that the San Andres Reservoir is in material balance, and there's no evidence of cross-formational communication. So I think those are pretty important points that should be, you know, reevaluated by the commission as they're thinking through what to do following this proceeding. I think that, sorry. So for these reasons, you know, Pilot respectfully supports the motions for rehearing. We urge the commission to grant rehearing for the limited purpose of reconsidering the suspension provisions of the order to clarify the commission's findings of no current waste or impairment, and to reaffirm that any suspension of injection authority must rest on specific findings of failure to confine injected fluids under 1915-26-10E. And this approach, we think, respects the commission's prior work, corrects procedural inconsistencies, and restores the certainty that the Oil and Gas Act requires. Thank you.
Thank you very much. I will open the floor to commissioners again for questions for any of the parties.
Thank you, Mr. Chair. I do have a couple of questions, at least as I think through this, to help me at least to be able to make some decisions here. I will start with OCD. So in your pre-hearing statement, and even you touched on it today, so on page 4, item number 3, OCD's request that the OCC provide the OCD a deadline framework for suspension of Goodnight's SWD's injection permits, OCD's suggestion. So my question to OCD is, why, based on the OCC order, why is it difficult for OCD to actually move forward and implement? You made some suggestions as to the procedures, as let's say some of these SWDs can be shut. So why OCD do have these processes? Why is OCD believing that they do not have enough information to be able to execute the order?
So a few points on that, Dr. Mpoma. First is in reading the order, and OCD would agree with Rice's point that paragraph 3 from OCD's perspective does not actually specify an immediate suspension or a future suspension, but there's potential here for an implication that there's a contingent event before suspension could occur. And that's the last clause after Rhino, in order to provide Empire with an opportunity to establish the CO2 EOR pilot project. That's the main, so the threshold question from OCD is, when does this suspension actually, is it effectuated? Because it can really be effectuated under two conditions here, or at least as the evidence has been provided and the arguments have been made. One of them is effective upon issuance of the order, or say, 90 days later, some other very date certain determination. The second option would be is that suspension would become effective, or it would be triggered by a certain action by Empire in regards to the EOR. OCD is very careful about suspending permits because those, while will in no way claim that they are constitutional interests of any kind, nothing of that sort, they do remain financial interests that are owned by operators. And so OCD does not take it lightly to just suspend a permit, just sort of ad hoc or without any concern about the effects of that. Now, in addition to that, OCD likes to supervise these wind downs of these wells with certain filings. This OCD's response was not intended to be a catch-all with all the detail that would be expected if there was a reconvened hearing. So that's why OCD is seeking clarification from the commission as to precisely what it wants OCD to do. Now, when OCD conventionally does suspensions, they do that under enforcement proceedings, which, while they certainly can appear before the OCC, most of the time they simply don't. And that's the end of it. And it's OCD's discretion that's in play because the OCC is not brought in. And since both OCD and OCC have concurrent jurisdiction in this instance, OCD prefers to defer to the commission, sitting as the final adjudicator of this matter, to provide that guidance.
Thank you, sir. So I'll move down to number 6, page 6, item B. If OCC seeks a suspension date that is not immediate, OCD recommends tying the suspension of Empire's accomplishment of specific criteria tied to Empire's EOR project, such as date of first injection by Empire. So my question to you is, does the commission, do you have the authority to really impose some strict deadlines on Empire?
I am cautious about advising the commission on its authority because that is not necessarily my role. But from OCD's perspective, the commission, OCD doesn't see why the commission wouldn't have that authority. Here, the Enabling Act, the Oil and Gas Act, provides extraordinarily broad authority to the commission. So I don't think there's a restriction on the commission. I'm sure there may be counter arguments to that I would genuinely be curious to hear, but OCD does not see any prohibition or restriction on the OCC's authority to provide more detailed deadlines, compliance, et cetera. Now, alternatively, and I didn't push this argument terribly hard in the response, if the OCC wishes, they can give OCD essentially what amounts plenary authority to enforce, with a few clarifications I think are necessary, like when the suspension is in effect. But I think that's also an option to allow OCD to conduct this as it sees fit, so long as it accomplishes the purposes and the intent of the order. That's not also made clear here, given there's some language that there's some conflict in the final order, what is it, 24004.
I would like to ask the other parties if they can provide a response to the same question that I just posed to OCD.
On behalf of Empire, I'll take a shot at it, and Ms. Hardy can clean up behind me. Certainly, there is sweeping authority and discretion on behalf of OCC. The issue here with the idea of a milestone approach is, one, that was in no shape, form, or fashion part of the OCC's final order that suspended the permits. Secondly, there was zero technical testimony during the development of the case to inform a staged approach. And so as you look at economic aspects, as you look at technical aspects, as you look at permitting aspects of the tertiary EOR project in the San Andreas, what has come for the first time out of OCD's filing is completely arbitrary. There is zero technical testimony that was developed during the 4.5 weeks that anything they say there on paper could be achieved from an economic or technical or practical perspective. And so we understand the OCC's final order that we have 3 years. And Empire, consistent with its testimony, is prepared to execute and be back here within the 3 years. In terms of arbitrary milestones during the interim, or that would somehow affect Goodnight's clear obligation to immediately suspend injection so that the pilot can go forward, there's zero basis for that in the text of the commission suspension order. So I'm not sure if I hope that answered the question, but again, what OCD came up with, they didn't point to any instance in the history of time that the OCD has actually staged. I wasn't intending to be funny. I apologize to OCD if I was. But the idea of a staged implementation with milestones in the arbitrary fashion that came out of Mr. Moander's filings, there was 0 point to any time historically that's ever happened before. And again, it is utterly arbitrary because there was zero technical testimony about the idea of that being feasible. Ms. Hardy, is there anything I could have said better or more accurately?
No, did a good job. Thank you.
Just Dr. Mpom, if I may just confirm the question that I'm answering. Is it whether the commission has authority to impose? Okay. So I think in this instance, the commission would have broad authority. If it's going to authorize or request an EOR project, it would have authority to put some guardrails on what that process would look like. And I think as Mr. Morander said, the commission does have broad authority, especially in areas where it does have clear jurisdiction under the statute, which is to oversee injection EOR projects. And here, as I read the order, I tend to agree that I read the order initially to suggest that injection would not be suspended, would only be suspended contingent upon the commencement of an EOR project. So to address the question about, well, what would those milestones be? There are a few things we know have to happen for an EOR project to be approved or to go forward. The first of which is there needs to be an application filed for CO2 injection. And so what milestones might fall from that? Well, we simply would look to the application that Empire itself files. What is it planning to do? And then we can dictate from that what the milestones should be. If Empire is ready, willing, and able right now to go forward with an ROZ, then let's see the application. And then from that, we can determine what the milestones should be upon which an orderly and scheduled shut-in or suspension can be implemented. Again, the way I read the order and the way I understand the intent is that the injection of Goodnight need not be suspended until and when and if Empire actually commences injection. Key to that for an EOR project, key to that is it has to be in the zone that Goodnight's injecting into. If Empire decides to pursue a different interval, then it's not clear to us that there would need to be a suspension of injection. But that's for the commission to dictate. But as to the milestones, I do believe the commission has broad authority. I think if there's any question about what the milestones should be, we could certainly have a narrow rehearing on what those are, or simply look to what application Empire actually files to dictate what those milestones should be.
Thank you. So back to OCD. So is it OCD's position that the current order does not provide enough room for OCD to work with Empire, to implement the CO2 EOR project within the 3 years?
I wouldn't go that far, Dr. Mpoma. OCD wants well, I think the threshold issue for that determination is how the suspension of Goodnight's permits would operate. Getting clarity on that would certainly make it easier for OCD to start requesting information and, as Mr. Waymeyer said, put arbitrary deadlines on Empire's performance, which actually are not going to be arbitrary. There are processes that do exist that apparently Empire is unaware of at the moment. But that's really the threshold issue to make that determination. Would be when are they what is the OCC wanting done with those permits? Because again, if they're tied to performance milestones by Empire, then that would change how OCD approaches this.
Now to Empire. So you asked about, the rehearing that you are requesting is for the commission to completely shut the SWDs from Goodnight. Is that a fair description?
It's the mere distinction between suspended from September to 3 years versus permanently revoked. This is New Mexico's minerals. This is United States minerals. This is Empire's vested leasehold. We think the evidence was sufficient and conclusive so that right now we can just say those 4 permits are full stop revoked. We respect the commission's decision about the 3-year suspension, but suspension means suspension, not curtailment. If the commission was disinclined to permanently revoke, and we understand that that's where your decision is, and we respect that, despite the rehearing papers, the suspension means suspended. You cannot inject if your permit is suspended, and the commission said present tense, the 4 permits are suspended. So there should be no salt water going into that hole while the permit is present tense suspended.
So on that, my question to Empire is, if you look at the 1984 order, we discussed during the entire hearing about the intent of the San Andres being added to the unit. There was a lot of discussion about that. So my question to you about what you are requesting, so after the 3-year period, or let's say at some point, Empire believes that this project is not economical and they don't want to progress on that project, would that more or less support why the OCC probably would say, let's suspend for now?
I understand the commission's reasoning. And so I think if I take it in pieces, here is why. So I've told you, we're going to execute in 3 years on the pilot. If the commission wants to know why is it important to Empire that right now the rehearing be granted to completely revoke, we heard about $5 billion in gross revenue, $1.5 billion approximately in royalty to the state of New Mexico and to the United States. This requires hundreds of millions of dollars in CapEx expenditure to execute that project. And consistent with what Mr. Macbeth conceded for Goodnight on the stand, if it's permanently revoked, as we think the evidence is conclusive it should be, then it's a lot easier to go forward in terms of executing a larger program, but whatever that looks like, whether that's just Empire, whether that's partners, whether that's raising money, whether that's borrowing money. And so in terms of people, consistent with what Mr. Macbeth said, as third parties or internal parties, investors look at the project, the revoked is important. But if the commission is disinclined to revisit its decision and to leave it as suspended for 3 years, we are going to make this a success. We will be back on or before 3 years to show the commission that at that point in time, permanent revocation is appropriate, so that we can go forward and get this value out of the ground and avoid the waste of the state's natural resources.
Thank you. Let me turn my attention to Goodnight. and I read through all your briefs. I appreciate that. Now, I just want to ask you, is it Goodnight's understanding that some way, somehow, the commission is tying the decision to suspend the injection to the performance of the EOR?
Commissioner Ampoma, the way the order was written, the way the order was written and the findings that were made and the conclusion that the order would be implemented by the division, as both Counsel for Rice and the division stated, it appeared to be potentially contingent on the Empire going forward with an EOR project. And because it was delegated or delegation of the order was the implementation of the order was delegated to the division, it was unclear to us what was the intent. And if the intent of the commission was to fully delegate that to the division, which is why at the time the order was issued, I asked a series of questions to understand as best I could what the intent of the commission was, whether there was intended to be an immediate shut-in. So I asked that question. And the response I got was that it was the intent of the commission to delegate the implementation to the division. So to answer your question, our understanding was that it was a little unclear, but that the intent was to delegate implementation to the division to implement suspension of the injection pursuant to the discretion of the division. Our view was that the guidance provided in the order was such that suspension could be, injection could be suspended only as and when an EOR project was commenced.
So I'm reading through your, this will be your pre-hearing statement, Goodnight Midstream LLC for the application for rehearing. I'm reading from page 3, and I'll start from the last paragraph. And start with second. The order creates two clear constitutional conflicts. One, they erroneously affirms the unitization of the public waters in contravention of the New Mexico Constitution. But I'm not interested in that one. Let me go to the order confirms there are no recoverable hydrocarbons in the San Andres and was included in the EMSU as a source of water supply violates the Statutory Unitization Act. 2, until there is an actual finding that there are recoverable hydrocarbons in paying quantities in Goodnight San Andres disposal zone and an exhibited failure to confine injected fluids, the order constitutes an impermissible regulatory taking of both Goodnight's property interest and the surface owner's pore space in the San Andres zone. So I do have a couple of, I just want to have few clarification on this one. I thought there was a lot of evidence, a lot of discussion during the hearing about the containment. We asked a lot about it. And if I recall correctly, Goodnight's response was that we are injecting into a vacuum. Now, you also talked about Empire did have the burden of proof, but I thought it was clear that each parties had their own burden of proof. So, do you believe that Goodnight was able to show the commission during the hearing, this is how much I'm injecting and this is where it is during the hearing?
So I think the answer to your question is, I think the burden that we need to prove there's two different things, just to break it down. There's a burden that Empire had to carry for its affirmative burden for its applications for new wells. Okay. And that was to demonstrate that its proposed injection was going to be confined within the injection interval. That's for the new applications. Conversely, as the applicant seeking to revoke Goodnight's existing injection, Empire had the burden to show through proof that Goodnight's existing injection exhibited a failure to confine the injection fluids into the disposal zone. That was its affirmative duty to prove. During the course of the hearing, I believe that Goodnight successfully showed that its injection fluids were not leaving the San Andres disposal zone. They were being confined within that interval. Whether it's to what extent it went horizontally is not an issue for the regulations or for its under the governing regulations. The question is whether it's being confined below and above. And based on the evidence adduced and the engineering and injection data, I do believe that showing was made and that we confirmed through evidence that Goodnight's injection was staying within the disposal zone.
So I'll turn to the order. And item C, I know we've had a lot of discussion on that today. So I'll just read that. However, the commission concluded it is premature at present to grant Empire's application to permanently revoke the injection authority of the existing wells because the commission found Empire did not adduce substantial evidence that their correlative rights in the Greenberg are currently impaired by Goodnight's injection into the San Andres. So on this one, is it this provision that Goodnight is saying that the commission says that Empire's resources are not impaired?
So there's two reasons we're saying we understand that Empire's resources are not impaired. Number one, the primary one, is that the purported ROZ has been determined not to be recoverable. Currently, they have not demonstrated recoverability. They cannot show that it's being recovered or can be recovered. And if it can't be recovered, then there's no waste, then there's no impairment. There's no share of production that they have a right to that we're preventing them from obtaining. Okay, so if there's no recoverability, then there's nothing at risk, there's nothing that's been harmed, whether you're looking at waste or impairment of correlative rights. So that's as to the ROZ, and that's specifically as to the San Andres. Okay. Now, as to the Grayberg, this next section here addresses primarily potential impacts to the Grayberg. Here, as I understand the order and the findings, unlike the potential future impairment that the commission found, there has been no demonstration of current communication between the San Andres disposal zone and the overlying Grayberg. The data, engineering data, the pressure data, and the injection data presented by Goodnight was, I understand, to be found compelling to show that there is no communication between the disposal zone and any overlying zones as laid out here under paragraph C. So because of that, and because there's no hydrocarbons that are recoverable in the San Andres, and the only potential impairment would be operations in the Grayberg, and there's no finding that there's been any communication to the Grayberg, there's therefore no impairment of any correlative rights in the MSU based on the commission's findings.
So then we are all on the same page that C provision was just specifically to the Greenberg.
Correct. I agree. And another finding in the commission's order that there is no ROZ that's recoverable addresses the San Andres.
You're saying that in the order, the commission made it clear that the ROZ is not recoverable?
Yes.
Can you point me to that?
I'll have to take a moment to find it, but I know I cited it several times in the rehearing.
Yeah, and it was interesting. I saw that. So during the hearing, there was, okay.
I have it. Sorry. So it's the next paragraph D, and it's on page 10 of the order, paragraph D. In addition, the commission concluded it is premature at present to grant Empire's applications to permanently revoke the injection authority of the existing wells because the commission found there was insufficient evidence presented at hearing to prove whether the ROZ is recoverable. So there's no evidence that it is recoverable. Having found that it's not recoverable at present, there's no current finding that it's recoverable. There is no, therefore, it can be no finding of waste and no finding of impairment of coral rights in the San Andres, because that's the only potential hydrocarbon in the San Andres.
So the use of insufficient evidence, and so is that what you are interpreting, that was entirely no evidence presented to the commission?
Well, again, as to each party, we each have a burden of proof. And the burden of proof is preponderance of the evidence. And because under that standard, the commission found that there was insufficient evidence, meaning they did not meet their burden of proof. They did not meet the preponderance of the evidence standard. There's been a finding that there is no recoverable hydrocarbons in the San Andres.
So from engineering point of view, during the hearing, the course of the hearing, I recall that, in this type of project, you have to do the, you would have to go through the scoping period. And during the hearing, Empire presented that. That will be your first pass of the scoping. And normally you have to use analogous information to be able to back up your analysis. And doing that, we believe at that time, I think the discussion going back and forth, we really need more specific site field information. So maybe you and I, we are reading a different meaning into the insufficient evidence. So don't you believe that at least there was some scoping analysis that was presented to the commission to prove that this ROZ could be recovered?
I disagree respectfully, Commissioner Ampoma, because the scoping analysis that was done, remember, was a Kinder Morgan screening tool. And it used an 18% oil recovery that was unattached to any data from the EMSU. And Empire, during the course of the hearing, failed to connect that 18% recovery to any data, not only within the EMSU, but to any other analogous field. Further, it didn't even identify whether that scoping tool was applicable to a conventional oil field or to an ROZ. And we presented contrary evidence through Dr. Lake that, in fact, the 18% recovery factor is several standard deviations above what even he identified through actual data is reasonable to expect in a conventional field. And he had uncontroverted testimony that the recovery factor is more likely to be in the range of 1% to 6%. So I do disagree that actually the evidence and the record establishes the converse, that they did not present any reliable or testimony based on any actual data tied to the MSU that there could be any recovery of any of those hydrocarbons. And that was, I understand, the findings of the commission.
And don't you believe that that is also the reason why the commission in their order specified that Empire has to proceed with a pilot project to prove that?
So I do understand that's why the commission wanted them to go forth with that project. However, the time for the game has passed. And what happened is Empire had an obligation to come forward with this evidence. And it came forward to the hearing with its evidence, and it didn't meet the standard of proof. And so at that time, as we sit here today, there's no evidence that any of those potential ROZ hydrocarbons are recoverable. And so I understand the division, the commission is interested in potentially seeing what the future holds. But because there's been no evidence showing that there's an impairment or waste in the San Andres disposal zone, there's no basis to shut in Goodnight's injection.
Thank you. I will pause here. I think I have all the answers. So I appreciate that. Thank you.
Other commissioners or council? Question?
I don't have any questions either.
My only question is procedural at this point. Do two parties provided demonstratives or slide decks or whatever you want to call them? Do you wish them to be admitted into the record? Is there any, and if so, is there any objection?
Well, I haven't had a chance to look at all the pages that are here. I suppose I don't have an objection to pages 1 through 31 being submitted, but I do have an objection to the others.
Well, do you even want them admitted as part of the record?
I think,
First question.
yeah, I think just given how carefully the proceeding progressed on all matters of evidence and what was actually filed, Empire's position would be that it would be safest to just have them not admitted as part of the record, but both sides have given physical handouts. They could be used if helpful or not, but not be part of the record would be the Empire preference.
Is that fine?
I agree.
Fair enough.
Yeah.
All right, that's all we've got. I think you have all given the commission a lot to think through and to sort through. So at this point, I'd like to invite a motion for the commission to go into an executive session so we can sift through all of the arguments presented today.
Mr. Chair, I do so move.
May I have a second?
A second.
Hearing no objection.
A vestige of the law requires a roll call.
Okay, Commissioner Ampoma, do you approve?
Approve.
Commissioner Chang,
Approve.
Commissioner Lampkin,
Approve.
Thank you all very much. I don't think you all need to stick around for the rest of the day. If we have anything to announce, I'm sure we can announce on via the online platform if that is sufficient. But certainly you are all welcome to stay if you wish.
And just for clarity, that because there was an open possibility of today and bleeding into tomorrow, the online announcement, no one would be here physically tomorrow.
No, I don't think so. I'm sure. Yeah, I'm sure we. Hopefully, I mean, it's already what? Oh, it's only 3:18. So maybe we can get this done today. But if not, I'm sure whatever happens when we come back out of executive session will merely be an announcement of whatever decision has been made.
Thank you so much for the clarity.
Thank you.
Hi, Kelly. Is the court reporter on? Kelly Gallegos?
Yes, I'm here.
Hi, Kelly. I've talked with the commission and they said that you don't have to stay hanging on the line.
Oh,
So I've
great.
spoken with Veritext and I'll give a call if we come back into open session this evening. I know that they'll only be available until about 6 o'clock, but
Okay, or
we'll
you
give a
can take,
call.
you can
Okay.
take my number and just text me directly.
Oh, yeah, that'll work. Okay,
You
I'm
wanna do
ready.
that? Okay, it's 505
Mhm.
238 8726.
8726. 505-238-8726.
Right.
Okay, that's fine. Yes, you don't have to stay holding on. And so I'll give you a call if we come back on this evening.
Okay, thanks a
Okay.
lot.
Thank you. Bye-bye.
Bye.